Good morning, Council. Welcome to this morning's session of the Kansas Court of Appeals. I'm Judge Catherine Gardner, and I will serve as your presiding judge today. With me also is Judge Kim Schroeder and Judge Amy Klein. So I believe the next case on our docket is set for 15 minutes. It's number 123569 in the matter of the marriage of William C. Murphy, appellant, and Dalia G. Murphy, appellee. May I have your appearances, please?
Your Honor, William A. Vickery for the petitioner appellant William Murphy.
Thank you.
Good morning, Your Honors. Jeffrey N. Lowe for the appellee, Dalia G. Murphy.
Thank you. Mr. Vickery, you may begin, and please let me know if you'd like any rebuttal time.
Yes, Your Honor, I would like to reserve 3 minutes, please.
Very good.
May it please the court. This case is simply a matter of law. We have no disputed facts. It's interpretation, in my opinion, of the Klein case and this court's intention when it reversed the district court in Klein. There's two issues that I briefed. First, did the court have subject matter jurisdiction in October of 1986 to award lifetime alimony to Dalia Murphy? The answer is no, because there was a specific statute in place that stated there had to be a property settlement agreement in place, which was incorporated into the decree of divorce and found by the court to be fair, just, and equitable. That did
Mr.
not.
Vickery,
Yes.
let me ask you a general question, because it seems to me that if a court exceeds the bounds of a statute, that doesn't necessarily mean that it lacks subject matter jurisdiction. It means that it abused its discretion or it violated the statute. But here, obviously, a court has subject matter jurisdiction to award, a family law court has subject matter jurisdiction in general to award alimony, correct?
Yes, ma'am. Yes, ma'am.
So why is this a subject matter jurisdiction issue?
Your Honor, in the Klein case, the court reversed on the issue of subject matter jurisdiction because there was not a property settlement agreement incorporated into the decree of divorce. That was the basis that they used. They found that the judgment was void under 6260B4. So I'm relying on your court and the finding in Klein as the basis for our appeal in this case. And go ahead.
Go ahead.
I think it's significant that the court in Klein pointed out specifically that Mr. Klein did not object to the lifetime spousal maintenance. In fact, they specifically said when they modified the child support, the amounts, and the spousal maintenance, the amount, the court in Klein specifically pointed out that he did not disagree with leaving the spousal maintenance terminable upon petitioner's death or remarriage. So he did, for all intents and purposes, agree, just like we have in this case. He agreed to lifetime spousal support. And then in the Klein case, after his children turned 18, it's apparent he went and talked to an attorney and he said, I'm tired of paying this lifetime spousal support. What can I do? And they filed a motion and the district court said, well, no, you had an agreement. And so we are not going to terminate the spousal support. This court said no. In fact, in syllabus 2, this court said non-compliance with statutory authorization is reversible error. And that's exactly what happened in this case. The Murphy divorce decree, I can show to any family law attorney. I can put it down in front of them and say, is this a decree of divorce that incorporates a family or a property settlement agreement? There is not one family law attorney who says yes. It simply doesn't say that. And it does not do that. And under the statute, The statute doesn't just have, as Judge Roush and Mr. Lowe have said, technical terms or magical words that are alternatives. They're required. Otherwise, why do we have the statute? And also, what's the role of the judge? Why do we have a judge in a case like this if he isn't to review this, find that there's a property settlement agreement that's in compliance with the statute, and find that it's fair, just, and equitable? That language is nowhere in that divorce decree. So we don't even really need a judge if we're just going to file these, rubber stamp them, and file them with the court. And the other thing I pointed out in my brief is in the Kirk case, this same court said, no, the judge has a role. The judge has to be active. He has to review these documents. He has to have information to find that it's fair, just, and equitable. And that did not happen in this case. There is nothing to indicate back in October of 1986 that any of that happened. And we would say the stipulation, that's something else. Judge Roush relied on the stipulation. Well, an agreement's an agreement. Statutes technical. We don't have to have the magic words, fair, just, and equitable. And I'm not going to find that the spousal support should be terminated. In fact, Judge Roush specifically said he thinks the dispositive difference between Klein and this case is that in Klein, the person defaulted against makes the difference. And it doesn't make any difference at all. And in Klein, we find out that Mr. Klein was in agreement with the lifetime spousal support until he found out he didn't have to pay it. And then this court said, you're right, doesn't matter. So I think the other thing that Judge Rouse, he pointed out the stipulation. He thought that the stipulation resolved the issue in Dalia's favor. Well, the stipulation was 35 years later. And the court, if you've looked at the whole file in this case, William did file a motion to terminate the spousal support back in 2001, and it was heard by Judge Dewey. And Judge Dewey believed that there would have to be an evidentiary hearing to determine whether or not there was an agreement between the parties for lifetime spousal support. That was just wrong. It wasn't required. And at that time, he said Dr. Murphy would have to pay $20,000 into Dalia's attorney's trust account to cover the cost of arguing that, when it wasn't necessary. It simply wasn't necessary as to whether there was an agreement between them. The fact was, it was not incorporated into the decree of divorce, just like in Klein. And so this court, you either have to reverse Klein, and really you have to reverse Kirk, if you're going to find that this document filed back in October of 1986 is valid to award spousal maintenance for the lifetime of Dalia Murphy. It simply does not meet the criteria that was required under the statute. Now,
so why didn't your client litigate the issue in 2001? I don't understand that.
Because Judge Dewey required him to deposit $20,000 into Dalia's attorney's trust account to litigate the issue.
Is that in the record? Is that in the record on appeal?
Well, no, there was a letter. Okay.
So we can't consider it if it's not in the record on appeal.
It's really, I'm just explaining to you how we got to where we are now, in that there was a misconception that the agreement was relevant to what was included in the divorce decree.
But in 2001, apparently your client was in agreement that there was an agreement for lifetime maintenance.
Right. I mean, and we've stipulated to that. We've stipulated to that. And he could have done that then. I don't know why his attorney didn't tell him, let's stipulate to that. Obviously, he didn't, because Judge Dewey believed that was the controlling factor. just like Judge Roush believed that was the controlling factor. But under the Klein case, it isn't. It's irrelevant. It's irrelevant. It has to
Unless-
be done correctly.
It has to be expressly incorporated into the decree of divorce.
Those are the words of the statute, yes. And those are the words that you cited in Klein, that the Court of Appeals cited, that it has to be set out. And the court has to review it. And the court has to find that it's fair, just, and equitable. The words fair, just, and equitable are nowhere in this document. There was a factual statement, very bare bones factual statement that was submitted by Dr. Murphy, but it really had nothing to do with paying lifetime spousal maintenance. This was a 14-year marriage, and he's paid 35 years of spousal support.
Mr. Vickery,
Yes.
doesn't the Rice case state that a judge's signature in the divorce decree is his finding that the proceedings are fair, just, and equitable?
Well, you decided in Kirk that that wasn't the case. The Court of Appeals Kirk case, that the judge does have an obligation to look at the facts in the case. But I would point out to you that the Rice case was decided before the statute was changed in this case, before there was the requirement that the court specifically find under the statute. Rice was maybe 5, 6, 10 years prior to this statute coming into effect. So the Rice case really is irrelevant. And the issue in Rice is different. They were looking at a different factor. I have that here. In Rice, there was an agreement that was approved by both attorneys for both parties. And there was evidence disclosed by both parties to the judge. They pointed out that there was a divorce decree that was drafted by the attorneys. And I think they assumed that the court assumed that if attorneys drafted this and each was represented, that it was probably fair, just, and equitable. And in that situation, then the judge's signature would serve to make that finding. But that's only half the test here. That's only half of what we're looking at. And I think that the Court of Appeals decided that Rice, it takes more than that. Otherwise, why did you decide the Kirk case the way you did? It wouldn't make sense to say, well, the judge's signature suffices, because in Kirk, you said that's not true. We're not going to do that. Judge has an obligation to look at it and decide whether it is fair, just, and equitable, and to have adequate facts to do that. All of the cases cited by Dalia and Mr. Lowe, every single case, it is undisputed that there was a property settlement agreement between the parties. One case, it was recited into the record in open court by each of the parties. In all of the other cases, each side was represented by an attorney, or each side signed the document to indicate that they agreed. There is no case other than Klein which holds that an oral property settlement agreement that isn't incorporated into the decree of divorce and states that it's a property settlement agreement between the parties is valid to extend spousal support beyond 10 years. It's a jurisdictional issue. That's what the court decided in Klein. And if it's a jurisdictional issue, we can't make a void judgment all of a sudden valid by a stipulation 35 years later. Like I said, the agreement doesn't make a difference. And again, that was the same in Klein. If you look at the facts closely, he agreed. He did not challenge the term of the spousal support when he said this is not our agreement. And this court pointed that out in its opinion. So with that, unless you have other questions, I can conclude this part of my argument.
I don't.
Thank you, Mr. Vickery. Mr. Lowe, you may proceed.
Thank you, judges. Thank you, Mr. Vickery. Dr. Murphy should lose on his 6260B4 motion unless he can somehow convince this court that the parties had no agreement for lifetime alimony. Party stipulation and the district court's ruling suggests and finds these parties did and such have an agreement. That is a key distinction in this case as opposed to Klein. And I want to start with the Klein decision, because Mr. Vickery believes that to be the controlling law in this case. In Klein, please review it. The court didn't find the existence of an agreement, and that finding is key. The Klein decision specifically makes reference to the enforceability of oral and written agreements incorporated into a decree. In Klein, unlike this case, you did not have the signature of the judge and the signature of the challenging party to the decree. Dalia's signature to the divorce decree is not essential. She's not the one complaining of the lifetime alimony order from the court. And let's break that down. Mr. Vickery in his brief, or Dr. Murphy better, talks about void orders, and he cites the statute awarding spousal maintenance. There's a difference between void ab initio and a void judgment that we must distinguish and talk about today. Had the party's order for spousal maintenance been the result of a trial court ruling following a trial or an evidentiary hearing, I would agree with Mr. Vickery. The court has no ability or jurisdiction to award spousal maintenance beyond 121 months. But that's not the case here. In this case, it is stipulated and found by the parties and found by the trial court, the district court, that these parties had an agreement. Dr. Murphy signed his name to the document he prepared. It's clear and unambiguous in terms of the amount, the duration, the terminable or modifiable terms, or the lack thereof. It is clear and intelligently drafted. And Judge Gardner, you are correct. Judge Beasley's signature is also important back in 1986, because the Rice decision tells us that that signature incorporates a finding of fair, just, and equitable. And Mr. Vickery wants to bring up the Kirk decision. The problem with the Kirk decision as compared to this case, and there's no challenge that the record is insufficient. That's not an issue that's being brought on appeal by Dr. Murphy. He's not telling you there was a lack of domestic relations affidavit or a lack of this or a lack of that. What he's telling you is the journal entry lacks special words. That is a technical defect that is time barred and must be brought in a timely fashion, not 34 years after the fact, and not on his second motion challenging the exact same thing. This court has held twice, the Johnson case and the Martin case cited in our brief, that these types of arguments, i.e. a journal entry lacking this, that, or the other in terms of language, must be timely brought under KSA 60-260 subsection C. I believe it is either in Johnson or Martin. One was in 6 years and one was brought in 7 years. And the Court of Appeals and those two unpublished decisions both said those were not timely brought to challenge the technicalities of a lack of a journal entry. Well, if 7 or 6 years was insufficiently brought in a time manner or timely manner, obviously something 3 times or 4 times greater would also be improperly brought before the court. The Kirk decision, no one challenged the fact when that motion to set aside was brought. And go look at the Kirk decision. It wasn't brought 34 years after the fact. It wasn't brought 6 years or 7 years after the fact. It would be presumed that that motion was brought in a timely fashion. And that's key. And Judge Gardner, you hit the nail on the head. This isn't a matter of jurisdiction in the sense that the court exceeded its authority in ordering an agreement of the parties versus awarding spousal maintenance when that issue was challenged by the parties. And Dr. Murphy's signature to the journal entry is a key fact that distinguishes it from the Klein decision. Klein is further distinguishable for several reasons. First, the original journal entry in Klein was default judgment. Default judgments by their very nature do not incorporate settlement agreements. Dr. Murphy has inexplicably referred to the journal entry and decree of divorce in this case in his brief as a default, but that's not the case. Dalia, the respondent and the recipient of spousal maintenance, executed an answer to the petition for a divorce. Her answer was prepared and submitted to the court for filing. That's on our statement of facts. And by the way, Dr. Murphy filed the answer for Dalia, and that's also in the stipulated fact or the statement of facts in the appellee's brief. Unlike Klein, the journal entry and decree of divorce in this case was not by default, and referring to it as such is just not true and correct. Second, the parties in Klein never claimed that the default judgment incorporated a settlement agreement. That's not what was argued. Here, the parties have not only stipulated they have an agreement regarding property division and spousal maintenance, they stipulated that the journal entry that's in question regarding spousal maintenance is exactly what they agreed to. Finally, in Klein, the district court did not award spousal maintenance. It was an order, the district court in this case did not award spousal maintenance as it did in the original default judgment in Klein. That's the key distinguishing factor. Because there was no agreement, the court could have only awarded spousal maintenance in Klein. That's not what we have here. And we can go back to the Mckinley decision from 1940, and it cites a case from the 30s that this court has upheld lifetime spousal maintenance or spousal maintenance terms that exceed the 121 months threshold many times. While agreed upon that that's not the norm, lifetime spousal maintenance is not a new or foreign concept in Kansas. And parties under the basic contract principles, caveat emptor, can make their own agreements, good, bad, or indifferent. And the court favors parties' agreements. And Judge Roush on the district court level did a good job flushing that out for the court. In denying Dr. Murphy's motion to terminate spousal maintenance, the district court properly held that the journal entry and decree of divorce incorporated a valid and enforceable property settlement and separation agreement. Such an agreement allows parties to agree to any length of spousal maintenance that they see fit. In this case, the agreement was for spousal maintenance to be paid from Dr. Murphy to Dalia until the death of either party or until the remarriage or cohabitation of Dalia. Neither of those terminable conditions has occurred to date. While frameless,
let me
Yes, Judge.
interrupt you for a moment. When you're saying that the journal entry did incorporate the settlement agreement, is that what you've said?
correct.
That's not based on any language in the journal entry or in the divorce decree. It's simply based on an after the fact stipulation of the parties that they had agreed at the time.
That would be true. You don't see the words agreement in the journal entry. We will acknowledge that. But the Rice decision says that's not fatal. And Rice is still good law, Your Honor. The fact that Dr. Murphy has signed the journal entry that's in question and the court has signed the journal entry of question tells us that he acquiesced to the order of the court. And the Rice decision says that signature is key. And that's why the Klein decision is much, much, much different. Who was challenging the order in Klein? Not the person who acquiesced to the order at hand.
But doesn't our statute now require that the property settlement agreement, if it's going to be longer than the statutory term, for instance, a lifetime alimony, that the property settlement agreement shall be incorporated into the divorce decree?
It shall be incorporated, correct. And there's nothing under the law, Your Honor, that says it has to be a written agreement. It can be an oral agreement. Obviously, oral agreements won't have a signature of the parties. And that's a key distinguishing fact. And we've long upheld in Kansas many cases cited in our brief, the Tagasawa case, the Klein decision that Mr. Vickery holds so true and near to his heart, recognizes the existence and the validity of oral and written agreements. And obviously in an oral agreement, you're not going to have a signature of both parties.
So you're essentially saying that anytime there is an oral agreement of the parties, that it is per se incorporated into the divorce decree.
It can be, Your Honor, and the judge's signature is key. In this case, the judge's signature and the complaining party is key. And that's why Dr. Murphy's argument should fail. Not only that, Your Honor, 34 years after the fact, he's bringing this to the attention of the court. He's complaining about a technicality. And please reread the Johnson and Martin decisions about the technicality or the lacking of key language or wording in journal entries. Those have to be timely brought 34 years after the fact. And he complied with his own court order until 2011, when he started to lower the amount of spousal maintenance that he wanted to pay Dalia. And it wasn't until Dalia finally hired an attorney and started executing garnishment proceedings that Dr. Murphy refiled for the second time the exact same motion that's before the court today as what was filed in 2000 or 2001. And that's very similar to the Johnson case too, Your Honor.
But the circumstances here of the longer he goes having to pay this order seems to make it more reasonable that he would challenge it later in time, because the later it goes, the more egregious it becomes and the more unreasonable it seems for him to have to continue paying this.
Let's assume that you believe the agreement of the parties to be egregious and unreasonable. Let's assume that to be true, because that's basically what Dr. Murphy is now telling the court, is that the agreement is long. The problem is you cannot, judge, even if you wanted to, disturb an agreement of the parties that's been incorporated into a decree. And the statute in Kansas says as much. And we cite that statute and that law in Kansas. And I want to quote the Mckinley decision from 1940. And this is probably wherein lies the difference between the two parties' argument. Quote, "There is a distinct difference between what the court has the authority under the statutes to do with respect," and it's referring to maintenance, "in a divorce case and what parties may agree upon. A husband and wife are competent parties to agree between themselves upon a division of property and payments to be made by the husband for the support of the wife. When such agreements are fairly and intelligently made, they are uniformly upheld by the courts." End quote. Lifetime alimony, again, admittedly not the norm, isn't a new or foreign concept in Kansas. And you can, Your Honor, uphold an order that memorialized or incorporate an agreement of the parties. This was not an award resulting from a trial court and an evidentiary hearing. And that's the key fact. And because of that, it's not void ab initio. It's possibly void, but that void argument, according to the Johnson and the Martin cases, must be timely brought before the court.
Counsel, are there any terms of the oral agreement that are missing from the divorce decree?
In terms of alimony?
Correct.
Nothing.
I mean, isn't that also key in addition to the signature? We don't have any missing terms. I mean, the oral agreement is memorialized in the journal entry because it sets forth all the terms that the parties agreed to, correct?
You got it. The amount, who's paying, who's receiving, what terminable conditions, death of either party, cohabitation, or remarried. It's all there. And in fact, to our dismay, Dr. Murphy tries to tell the court that in the Rice decision, the key distinguishing fact in that case is only the amount of alimony was in question. Well, we disagree, and we flush that you have to look at the totality of the circumstances. But even if you believe that to be true, we're not missing the dollars and cents of the amount of alimony in question. It is very detailed and very specific. Most importantly, it was drafted by Dr. Murphy, signed by Dr. Murphy, and approved by the court. To end,
So are you arguing that if there's technical words missing from the journal entry, that's basically Dr. Murphy's fault?
No, what I'm telling you, Judge, that if you want to listen to a technical defect argument within a journal entry that's been signed by the complaining party and signed by the court, that motion has to be timely brought. The Johnson and the Martin decisions tell us as much. And this court, those are both decisions of the Court of Appeals. And I'm telling you that you should not even be persuaded whatsoever by a technical defect of a journal entry because the motion hasn't been timely brought. We'll argue that the parties' agreement, which was stipulated to, is clear and unambiguous in terms of alimony, and the court found as much, and therefore there is no technical defect. But if you want to give the benefit of the doubt for argument's sake that there is a technical defect with the journal entry, and Mr. Vickery said it in his oral presentation, the word agreement's never mentioned in the technical sense in the journal entry, that has to be timely brought in a timely fashion. And 34 years certainly isn't. And the fact that this is the second motion or the second bite of the apple is also telling if you want to look at terms of equity, but equity doesn't play into this, Your Honors. This is an agreement of the parties. Even if you believe it to be unreasonable, even if you believe it to be inequitable, you must uphold an agreement of the parties that has been ordered by the court and acquiesced in for multitude of years.
I was going to ask you, does course of conduct have any application?
Say that again, Your Honor, I'm sorry.
Does course of conduct have any application in this matter?
I believe it does, because remember, it's a good question. He's performed on his own contract. And under Kansas law, divorce orders that incorporate agreements can be enforced under divorce law and contract law. And that's the key part here. We have a contract between two parties, and he's performed on his own contract for years and years and years. And now he wants to complain about it. And again, not to sound like a first-year law school student, but caveat emptor, parties can enter into good, bad, or indifferent agreements. And if they're uniformly made, intelligently made, and his signature to the document suggests that's exactly the case, they're going to be upheld by the courts. That's been the long-standing law in Kansas for years and years. And we cited the McKinley case that cites a case from 1937, I believe.
Mr.
Finally,
Lowe? Yes, if you'd like to sum up, your time's
yes.
up.
I want to read this holding from the Johnson decision, which is a Court of Appeals decision. The district court did not abuse its discretion in determining Lula, who was the moving party, waited an unreasonable amount of time in filing her 60B motion. There is nothing in the record to indicate why Lula's motion was not filed earlier. Obviously, Lula's concern regarding Conley's annual $500 contribution to the retirement account should have arisen the first year following the divorce. Lula stated that she sought therapy to address issues that plagued her marriage 2 years after the divorce, but she waited 7 years to file her motion to set aside the property settlement agreement. And Judge Schroeder, you hit the nail on the head. He could have filed his motion long before 2000, and he did file his motion in 2000, but for some explainable reason that's not on the record, that you don't know why, he abandoned that motion. And even then in 2000, that motion would have been untimely according to the Johnson and Martin decisions. Do not buy off on a technical defect. We will be opening the door in Pandora's box to setting aside journal entries across the board that are lacking this or that, but are substantially in compliance with the law. That's what we have here.
Thank you, Mr. Lowe. Mr. Vickery, you have 3 minutes rebuttal.
Thank you. I would like to point out that the Marriage of Martin case was unpublished. There was an agreement that was signed by both parties and incorporated into the decree of divorce. In the Johnson case, same thing. There was a PSA that was signed by both parties. It was incorporated into the divorce. That made time a factor. This court in Klein specifically argued, the other side argued acquiescence and time. And this court found in a void judgment, time does not matter. It can be 50 years later. Acquiescence does not matter if the judgment is void. That's what this court said in Klein. And in Klein, Mr. Klein did approve lifetime spousal support. He had his bite at the apple to modify the journal entry when they did an agreement to change the amount of child support and the amount of alimony. And this court specifically pointed out that he left in there that spousal support would be terminated upon death or remarriage. So that's no different from our stipulation that we have here as far as an agreement between the parties. A default judgment is something where a party does not appear. The decree itself says Dalia Murphy does not appear. it indicates she did not participate in that document. We call these the default divorce docket when one side does not appear. Now, usually they've signed the decree, but in this case, it truly is a default because she didn't appear. She didn't sign the decree. She didn't approve it. So I don't think it makes any difference, but it is a default judgment. Anything going back to 1940 on spousal support doesn't matter because the statute changed in 1983, where the legislature specifically limited spousal support to 121 months with the right to ask for an extension by motion if the court allows that, or if that's in the property settlement agreement between the parties. But otherwise, there cannot be a document that authorizes support for lifetime. I think that's all I needed to point out. The cases cited by Mr. Lowe, time is not a factor in a void judgment. You said that in Klein. Acquiescence is not a factor. You said that in Klein. And in Klein, there was an agreement between the parties for lifetime spousal maintenance, which this court said you can't do because it wasn't done right in the first place. So I'm asking the court to reverse the trial court and find that the spousal maintenance should be terminated. Thank you.
Thank you. We appreciate the oral arguments by both counsel, and we will take the case under advisement and get you a decision as soon as we can.
Thank you,
Thank you,
Judge.
judges. Thank you, Mr. Vickery.
Thanks, Mr.